All right, welcome to the webinar on privacy, antitrust, and big tech. My name is John Yoon. I'm an associate professor at the Scalia Law School and the director of economic education at the Global Antitrust Institute. And I have a distinguished panel with me today, and I'm going to just go ahead and introduce them and then talk about the format. Just have a quick opening statement, and then we're going to jump right in. First, we have Jamillia Ferris. Jamillia is a partner at Wilson Sonsini and also worked at the Office of General Counsel at the FCC and as Chief of Staff and Counsel at the Antitrust Division at the Department of Justice. We also have Bruce Hoffman. Bruce is a partner at Clearly Gottlieb and recently served as the Director of the Bureau of Competition at the FTC. Before that, Bruce had been an antitrust partner in private practice and served as Deputy and Associate Director of the Bureau of Competition. We also have Michael Kades. Michael's the Director for Markets and Competition Policy at the Washington Center for Equitable Growth. Michael has also worked as antitrust counsel for Senator Amy Klobuchar and spent 20 years investigating and litigating some of the most significant and high-profile cases at the FTC. And finally, we have James Cooper. James is an associate professor at Scalia Law and the director of the program on economics and privacy, the host of today's webinar. So thank you, James. He recently served as the FTC's deputy director for economic analysis at the Bureau of Consumer Protection and was previously an acting director at the FTC's Office of Policy Planning. So again, thank you all for joining us, not only the panelists, but certainly the attendees. And so the format that we've decided on, since we only have an hour, is to jump right in. We're going to go with Q&A, and we're going to ask specific questions, and then we'll see if there's any reactions. And then from there, we're going to go to the end. We'll have some time for audience questions, whether during or at the very end. And so with that, I'm going to just say a quick opening statement, and then I'll start with the first question. Antitrust went from a fairly sleepy area of the law with an occasional influx of interest with big cases such as the Microsoft case or Staples Office Depot, AOL Time Warner, to really something that's been in the spotlight. Specifically, one can hardly discuss the digital economy and leading platforms such as Google, Facebook, Amazon, and Apple without also discussing whether they have too much power and influence, both economically and culturally. So I think we're arguably at peak antitrust right now, with academics, foreign competition agencies, think tanks, and politicians all calling on the FTC, DOJ, the state attorneys general, and courts to really do something. Further, if these traditional avenues are unwilling or unable to really create some solutions, do we need a regulatory approach, either as a substitute or complement to the Sherman, Clayton, and FTC Acts? So that's obviously the broad overview, but we're going to hit on three themes today. The first of which is whether the digital economy is different, and if so, how is it different? The role of data and privacy will be our second sort of subtopic. And finally, we're going to try to get to acquisitions of nascent and potential competitors. And time permitting, we'll have sort of a final policy statement from each of our distinguished panelists. So with that quick introduction, let me start with Jamillia, focusing on digital platforms. What are network effects? Is a term we are seeing increasingly being used. Platforms, or also known as two-sided markets. And also, are there specific types of platforms, and does it matter? And what's your view of the lens of antitrust in terms of these types of businesses?
Sure. Well, thanks so much for hosting the panel and inviting me to be a part of it. This is a fun way to break up the day. So again, thank you for having me here. So I think my job in addressing this question is to just set the stage for the discussion today. At the same time, I think we know that we at least have some listeners who kind of understand the issues well. And, you know, I'd also caveat that these are kind of straightforward questions, but at the same time, you know, as you all well know, there's entire panels discussing and sometimes debating the contours of a two-sided market or multi-sided platforms and the specific impact of network effects in that analysis. So I think indeed you, John, moderated an entire FTC hearing on this issue. So I won't try to get into all of that here, both because, as you noted, we have a lot to cover. And most importantly, I'm not sure I would be the right person. I couldn't do the topic justice, given the breadth of the discussion. So instead, I'll just briefly cover a few foundational principles, with apologies to those for whom it's quite basic. But a network effect exists when a product or service becomes more valuable to consumers as more people use that product or service. So to give an example that's very real today, Zoom might be more valuable to you if the people you want to talk to or Zoom with have the same service you have. So there's nothing inherently good or bad about that. Although Zoom has become an eponym of sorts, the fact of network effects doesn't really say anything about whether Zoom will be a dominant teleconferencing services, particularly when most of us are finding more than one teleconference service useful and switching between the services is useful. But that's kind of the general idea of what a network effect is. A two-sided market or a multi-sided platform can serve as the intermediary that connects the two or more different parties, usually buyers and sellers, and it enables the interaction between those parties. So I'd say here again, it's not really that hard to come up with an example that we're relying on today. So Instacart, which is connecting us to grocery stores, DoorDash was connecting restaurants to consumers, particularly in my house, where even in a pandemic, I can't cook a decent meal. But in both of these examples, the platforms are also connecting drivers to restaurants and to consumers so they can get the food that's being delivered. So in a multi-sided platform, there are cross networks or indirect network effects. So this means that as the number of users increases on one side of the market, the value of the other side of the market also increases. So this requires the platform to kind of balance the interests on both sides of the platform. Now, network effects have the potential to influence the likelihood of competitive harm on platforms, although again, that's not always or necessarily the case. If the network effects on a platform are quite large, it at least has the potential to create a barrier to entry for other people who don't have the sufficient scale to compete. It's also possible that the first mover could gain large network effects and become dominant, even as others would be prepared to innovate. And because of this, a better platform might not be able to survive, but that's also not necessarily the case. As to sort of specific or different types of platforms, the Supreme Court in American Express described two kinds of platforms, transaction and non-transaction platforms. And so I think we're going to see a lot of action there. Transaction platforms, to the extent you can put a circle around those, require the two sides to directly interact on a platform. So Uber, for example. A non-transaction platform, the two sides don't directly interact. You asked sort of, whether platforms necessitate any special antitrust treatment? I mean, again, we have the Supreme Court holding in American Express that tells us when you're reviewing of the competitive effects of a two-sided transaction platform, you have to look at both sides of the platform. So it's treating it somewhat differently. But I think some of what we're going to talk about today is whether a particular platform should be treated differently or whether the antitrust laws are sufficient to address concerns that people have about some of those platforms and how they operate. I guess I'd say in my own practice, where I spend a lot of days looking at transactions and conduct involving platforms in general and businesses that have a platform type model, when you look at kind of the variety of platforms that could exist, I don't think there's anything inherent about those transactions where a platform is involved or conduct that necessarily requires different treatment per se. I think at the end of the day, it will come down to whether the competitive dynamics in which the platform is operating, how do those look and how do they affect the market? And that's no different than any other transaction or conduct. So that's kind of the baseline.
Thank you, Jamillia. With that, and to complement what you just shared, I'm going to turn to Michael. Michael, one notable feature of the digital economy is the widespread use of this zero price business model, at least on the user side. That's obviously the predominant model for Facebook properties, as well as Google, Snapchat, TikTok. But if we accept the old adage, there's no free lunch, what's the nature of the exchange of these platforms, given your experience? And how does that ultimate monetization come into play based off of this free model or zero price model? Oh, Michael, you're muted. I'm unmuting you. There we go.
So I guess I did the stereotypical thing. But let me start by just thanking you for having me on the panel. Right. So, the whole two-sided markets take a sort of different twist on what is a zero price. Right. So, but when you think about it, it doesn't really change the analysis. And let's just start just on the consumer side. The fact that you don't say pay for Gmail or pay to search on Amazon, that's just a point on an infinite continuum. So, right, there could still be anti-competitive harm, and because absent the anti-competitive harm, the price might be less than zero. Or if there were anti-competitive harm, it might be showing up in quality reduction. So, right. Sometimes people seem to think the fact that that there's no price on the consumer side means there can't be harm. I think that that's wrong. And in fact, what sort of building on what Jamillia just said, in a two-sided market, right? The idea is that the platform is trying to maximize is shifting prices on the two sides to try to maximize everything. So it shouldn't even be that surprising that in a market you might have free or less than zero price to one side, and with the other side paying a higher price. And again, I mean, that doesn't mean it's anti-competitive or not anti-competitive, but I think it really does sort of bring me to sort of where you ended, is when thinking about anti-competitive stories or competition theories with two-sided markets, you need to follow the money, right? So what you're concerned, right? So at the end of the day, you can't pay everyone. You can't be free for everyone. And in looking at a transaction or conduct, where there is zero or negative pricing to one side, you need to think about how that impacts conduct to the other side, right? And so it might be that the harm isn't occurring on the consumer side necessarily, but that the harm's occurring on the paying side, right? So if you engaged in sort of an anti-competitive conduct, and I'm sort of using that word intentionally very generically because I'm not sort of wanting to talk any specific conduct, as a way to foreclose, say, the entire consumers from other platforms, that may be the way in which you can impose anti-competitive effects on the pay side, right? So that's how. So it's important to think about how the pricing is working on both sides, and whether the pricing and whether that's being used to basically increase output. Like you got more people coming on both sides because it's just great, but it can also be part of the mechanism by which a monopolist could extract anti-competitive rents.
Thank you, Mike. And speaking of consumer harm, you raised a really good point, because the early cases involving Google, I think there was a decision saying because it's free, there can be no harm. It was like a proof. But as you said, I think we've reached rightly the point where there can be harm, and one of which, a theory of harm, is this bias. So Bruce, this is an idea that both the EU and FTC have looked at, this idea of search bias. So first of all, what is it? And my understanding is either the FTC or DOJ, someone's looking at it again along with the advertiser side. And so, there's sort of these issues of the duty to help rivals. Is that the right way of looking at it? Is this an essential facility? Is that a necessary condition for there to be some sense of not having bias? What this, Bruce, in terms of the intuition or how we should be thinking about this?
Sure. So I'm going to focus on this a little bit. Well, actually, let me start by thanking you, John, and everybody involved in putting this panel together. As Jamillia said, this is a fun way to spend part of the day, especially, I guess, if you're an antitrust geek, which I suppose I have to admit that I am. Not that the rest of you had any doubt about that.
Don't we all?
But, but look, I think it's, a useful way to answer this question is to kind of back up a little bit and say, what is search? Search bias is just one species of a form of conduct that you could have with a platform. And what this is really getting at is an area where there's been a lot of slogans, a lot of catchphrases tossed around. But what they really have to do with is the question of, if you've got a platform, as Jamillia said, somebody that's providing a place where other people transact. I'm a platform, and so people come and they do searches to find products, or they sell things to each other. I've got buyers and sellers. If I got a platform and then I vertically integrate, in other words, I have the platform and now I decide I'm going to do one of the things that's actually on the platform, is that a good or a bad thing, or is it neutral? And then what if I decide that my thing that I'm doing myself in the platform, I'm going to give some benefit to? So, for example, you could think of this to kind of get away from digital and simplify things a little. You could think of a mall, which none of us could go to right now, I suppose, but which I remember as something in the past that you would go to. And you could go to a mall. A mall is a platform. It brings together buyers and sellers, and malls might have shoe stores in them. And you can imagine a mall owner might say, you know what, I think I want to be in the shoe business as well, so I'm going to put my own shoe store in the mall. Well, that's a platform, and it's engaged in vertical integration. And maybe that platform, that mall, might decide to put its own shoe store at the busiest spot at the mall, or right at the place where there's going to be the most foot traffic, so to speak, and give itself a preference, or put its own sign most prominent on all the mall directories. When you look at the mall directory for shoe stores, instead of being in alphabetical order, the mall's own shoe store always comes up first. Well, it's easy to make a slogan that's bad. There's some sort of a sense of fundamental fairness where this sounds a little wrong. Senator Warren recently said, you can be the umpire or a player, but not both. So it's easy to have a catchphrase about this. The problem is that those catchphrases are just plain old wrong. They actually make no economic sense. And when you think about platforms and why they might vertically integrate, well, you have to remember a couple things about a platform. Number one, the platform doesn't actually care what you're buying and selling in the platform. It just wants more people buying and more people selling. So the platform's interest is to have the best experience possible for everybody on the platform. Number two, if the platform wants to make more money, if a mall wants to make more money, the mall doesn't need to make a shoe store, it just needs to raise rent to everybody. So there's no obvious anti-competitive reason why a platform would vertically integrate, nor is there an obvious anti-competitive reason why it would put its own shoe store in the best spot in the mall or self-preference. So when you look at this kind of situation, you should say, well, what is the most logical reason why somebody would vertically integrate and the most logical reason why you self-preference? Well, the answer is, if you're the platform owner, it's because you think doing that is going to drive more use of your platform. You're going to get more customers. They're going to be happier with the experience. They're going to stay longer. They're going to buy more stuff. So the first logical explanation for platform vertical integration and self-preferencing is actually pro-competitive. Does that mean there can never be an anti-competitive case? Clearly not. We know of two solid theories where there can be anti-competitive harm from this kind of behavior. Number one is where the platform perceives one of the verticals as a threat to its monopoly. This is like the old Microsoft Netscape case. If you think that shoe stores are going to take over the mall, you might vertically integrate the shoe stores to quelch that threat. If you think, the second theory is you might want to become a shoe monopolist, right? You might want to monopolize the vertical. And it's possible that vertical integration by a platform could allow you to do that. But those are very specific theories that have very specific factual and economic requirements for them to work. And so when you think about this as an antitrust lawyer and economist, what you do is you say, which of those theories is operable and do the facts fit it? It's not the case that as a matter of good economics or antitrust law, you would say, well, it's just bad or wrong for a platform to vertically integrate or even to preference its own products or services. It's much more complicated than that. And as I said, I think the dominant simple explanation for that behavior is usually pro-competitive.
That's our last question on digital platforms and the nature of the platforms. I don't know if anyone had any follow-ups or reactions before we move on to data and privacy. Yeah, go ahead, Michael.
So I think it may not surprise Bruce that I don't quite take the same position, and I think it's fundamentally wrong to say there are only two theories under where platform self-preferencing could be anti-competitive. And I think here to go up to 50,000 feet, what makes platforms interesting and different from other markets, at least some platforms, not all, but if you have network effects, if you have winner take that leads to tipping, which means you are going to have eventually you're going to end up with a dominant platform. I think it opens up it makes many types of strategic conduct that normally wouldn't be effective more effective, particularly in areas where we normally. So, for example, we tend to think predation strategies aren't very effective because it's hard to recoup. Well, that's not. It's much easier to recoup in a market where it tips. You only have to predate for a short period of time, and but when we look at what the experts are saying, right? You have the report of the Stigler Committee, you have the report coming from the UK, chaired by Jason Furman, and the EU done by Jacques Cremay, and the Australian Competition Committee, and all three of those reports are pretty clear that they think that certain platforms, precisely because of high entry barriers and tipping, make anti-competitive conduct like self-preferencing much more viable, profitable, and successful. So, I certainly agree with Bruce that there's no self-preferencing is not necessarily automatically anti-competitive, but I think for certain sorts of platforms, we do need to be more concerned about self-preferencing.
I'd like to give two quick responses to that. One, I think all that is basically correct. What I would say is that still the two theories of anti-competitive harm are the two I identified. Either you're preventing a threat to the platform monopoly or you're trying to monopolize the vertical. Those are the two theories, right? Because simple profit extraction you can do without the vertical integration. So the question that you have to ask is the conduct at issue and is the nature of the particular platform such that whatever is going on is likely and on balance in an anti-competitive way to produce the monopoly outcome either at the platform level or at the level of vertical. The vertical theories, by the way, I think are much less. You see a lot less of that. There's many fewer examples of the mall trying to monopolize shoes than the Microsoft type case where the platform is concerned about a threat to itself. But the second thing I would note is that both the Stigler Center report and the report from Jason Furman, the report out of the CMA, are long on possibility theorems and short on empirics. Right? There's not a lot of examples of cases where the possibility theorems of mechanisms by which platforms could actually achieve this result have actually been demonstrated to be true. Yeah, it doesn't mean it can't happen. And I think Microsoft Netscape is a good example where the evidence was fairly good that was what was going on. And the case, I think, looked like a good antitrust case. So I just think that my fundamental point here is simply that there's a tendency, particularly in popular discourse in the media, to just equate a platform vertically integrating or even giving its own services a preference to anti-competitive conduct. And I think that broad brush is inaccurate. Does not mean that there can't be viable theories of anti-competitive harm.
Thank you, Bruce, and thank you, Michael. I'm going to switch gears to our second topic, data and privacy. And James, as one of the leading scholars in privacy, can you frame the issue of privacy itself, how we should be thinking about this broad net of privacy, and how does that intersect with zero price platforms to the degree you want to address that, and also issues of antitrust and privacy paradox, but just some of your thoughts on that intersection of privacy and antitrust.
Yeah, thanks, John. Maybe we'll automatically get a lot of. I'm looking for when you said leading scholar in privacy. I'm waiting for the switchboard to light up and complaints about that. Already. But thanks again for hosting this and for being the moderator. And it's great to see some of my old FTC colleagues. It's been a while. Michael and I go way back to the Leibowitz-Kovacic days. So that was it's great to be on this panel discussing some of these things. So you asked kind of what about privacy. I mean, I teach a class on privacy, and we could spend an entire semester on that. So what I'll plan to do is just eat up the rest of the time. No, I'm just kidding. Talking about privacy. Now, what I want to do is maybe just talk more generally about the privacy antitrust interface, and maybe address some of those questions along the way. And maybe we can talk with other panelists, get into some of these areas a little more specifically. So, and I think part of this dovetails a little bit with what Michael had said a little earlier, talking about zero price platforms, and this notion, and I agree, it's completely wrong that if it's zero price, there can never be anti-competitive harm. That it's pretty clear in the antitrust laws, both the case law for Section 2 and for the merger guidelines, that quality and non-price dimensions of competition are important and viable theories as well. So I think when you look at these zero price platforms and the fact that many of them, some of the big ones we talk about, I'll leave them unnamed, but live off consumer data, and they're often embroiled in privacy issues as well, that it seems, privacy is the price we pay. We hear that out there, data is the new oil. So we'll just kind of say, we'll use this as a way to get at the antitrust, applying antitrust to these zero price platforms. I think that it has a facial appeal, but I think it's more complex than a straight analogy of privacy and quality. So let me talk through a couple of these things. First, I think one of the first hurdles you have to go through is how competitively important of a variable is privacy. And this goes to something you'd mentioned in your intro to the question about the privacy paradox. So, when you take polls, and it seems that privacy is this, 90% of the people say privacy is really important, or our data is out of control, whatever. You get these very high response rates as to, I care deeply about privacy. But then when you look in the real world, you see reveal preference suggests that privacy is not top of mind and not kind of a primary driver of consumer choice. So this is what's come to be called the privacy paradox, the gap between stated and revealed preference. Now, as an economist, John, you're an economist too, and I think economists typically like to go with revealed preference rather than stated preference. When you have to put your money where your mouth is, what are the choices you make? But there are a lot of theories out there, explanations as to why this privacy paradox exists. Rational choice, people just, when they have to put their money where their mouth is, they just don't care. There's also informational problems. There are theories that there's a lack of information, consumers don't understand. There's cognitive bias theories. The important point for antitrust, though, is I'm agnostic as to. I won't say I'm agnostic. I tend to, again, as an economist, I think that revealed preference is probably good at explaining it, but there are good theories out there that suggest that lack of information or bias is driving some of this. The important point, though, from an antitrust perspective, is that it doesn't really matter what's driving this. Now, so if the if we don't see consumers really making choices with respect to privacy that much, and it's being driven by rational choice, then clearly it's not really a competitively important variable. If the lack of us observing consumers making choices based on privacy is due to informational problems or cognitive bias problems or context dependence and things like this, that's not an antitrust issue. What you have there is maybe, say, like a lemons market, where I want to have a product out there that has good privacy, but it's too complex. People can't understand it. They don't believe me. It's the classic Akerlof lemons where the good quality, the high privacy can't exist. There's a dysfunctional equilibrium, for lack of a better word. The problem there, then, it's a consumer protection problem. I'm not saying that problem, I'm agnostic again as to whether that is an issue, but that's why we have the Bureau of Consumer Protection, and we deal with privacy that way. No amount of competition is going to solve that. That's what I mean. It's not that it's one, a turf thing. It's just that it's not a competition. It's not the lack of competition that's driving it. It's the lemons market. So it's a consumer protection issue. So this leads to kind of the second complication here. So let's even assume that privacy, so first it seems that, privacy isn't really that competitively significant to consumers. So second, let's assume, just for the sake of argument, that it is competitively significant, or we can find some places where it does seem to be competitively significant. You then have to identify some underlying conduct that's actually limiting competition, that's showing up as a reduction of privacy. Because, so for instance, I go back to the Google DoubleClick merger back in the day of the FTC, where there were urging to, hey, that this isn't really a competitive. There are no anti-competitive issues here between Google and DoubleClick. They were kind of ancillary markets, and they were complementary. But there was a lot of urging to say, well, it may reduce privacy, so you should block it in that respect. Now, unless we throw out case law like National Society of Professional Engineers, or go back and rewrite the antitrust laws, and I know we're going to maybe talk a little about that later in this panel, it's hard to kind of shoehorn privacy into antitrust that way. So what you're going to have to do is you're going to have to find some conduct. So in the dominant firm case, it's a bedrock principle of antitrust that a monopolist can charge any price they want or set any quality they want. It doesn't matter. That's if we're using the privacy quality analogy or the data price analogy, absent some kind of dominant firm conduct, that's something that is otherwise that is again limiting competition, that shows up as a reduction in privacy. You can't just say big firm, low privacy. There's got to be a causal link, and so I think that's another complication. And then finally, another point I think here is that this idea of taking more data or having less privacy is the same as a reduction in quality. It's more complex than that. So one example is, you think about a monopoly car maker who exercises market power, not by price, but say by holding price constant and reducing the quality of the car. I'm going to put crappier tires on my car. And so what happens there? Hold the price constant. I put a lower quality input in. My profits go up because my input costs are lower, and all consumers are going to be worse off. Now, because there's a distribution of tastes and preferences for tires, some will be worse off than others, but everyone's going to be worse off. So let's now look at that analogy in the case of, say, a data-driven platform, zero price platform. Let's say that I decide to reduce privacy. I start putting cookies on the people who come to my my site, my platform. And what happened? So I've done that, and first, it's reduced privacy. And let's say that privacy is a normal good, and so now we're kind of like the car with the worst tires. Okay, so it's the same there, but. And me as the platform, what do I have? Do I have an automatic profit? No, I just have servers full of data, and I have to do something with this. Okay, this is the underpants gnomes problem from South Park. They collect underpants, they want to make profit. They've got to have some way to do it. They couldn't figure it out, but platforms have figured it out. And what they do is they convert the data. They have to monetize it. How do you monetize it? Well, one of the most popular ways of monetizing is targeted ads. And what do targeted ads do? Well, they garner more revenue. Why? Because they're more likely to lead to a conversion, which is just another way of saying matching a consumer to something they want and they buy. It also creates more revenue to the platform, and platforms, drive that back in, and it leads to higher quality. We see this in the recent YouTube consent decree with the settlement with the FTC, the platform, they can't do targeted ads now and behavioral, and so they're worried about the quality of the output. So my point here is that it's more complex, that there's always going to be some trade-off. Now, some people are going to say on net, I don't like the privacy. I'm getting targeted ads. I'm having more data taken. There's a benefit, there's a cost, but on net, it's worse for me. But others are going to say, okay, on net, it's better. So to me, it's when you're talking about data, because data needs to be monetized by providing some benefit to some consumers, and because taste and preferences are heterogeneous, and because there's there are correlations between the demand for the product quality and for privacy. It's really complicated, and it's much more akin to a movement in a horizontal space, like a hoteling line repositioning, than it is moving in a vertical space. I'm giving you a worse car. No, I'm giving you a different car, and some people may like that different car. Some people may not. So I think those are some complications that arise when you try to put privacy into the antitrust domain. Not to say that, again, it's that there couldn't be the merger where you have two firms competing on privacy. The data show it, the documents show it, and you can find that. I mean, maybe that's a unicorn, and I'm not saying it's theoretically implausible, but I think it's that this analogy between privacy and quality is a little more complex, and you got to dig a little deeper.
Thank you, James. I'm going to turn to Jamillia and stay with privacy a little bit here. And there's certainly a movement in antitrust, given what James has said. There's certainly a movement to incorporate privacy and even political bias into the world of antitrust. And there was a recent German Facebook case, which I'm not going to know the full details of, but just very briefly, the Germans have found that Facebook was able to use its dominance to force terms onto consumers, which allows it to collect additional data or likes from third parties, which it asserts is in violation of its the European GDPR or privacy regulation that they have. So the idea is that this data is cementing Facebook's dominance. So maybe that's the window in which they're navigating James's point about you need some conduct. So what are ways that large digital platforms can extract data from rivals to the detriment of competition? And are there pro-competitive justifications? And so I'll throw that to you, Jamillia. Jamillia, we can't hear you.
Sorry, yeah. It's been a while, so I put it on mute. So yeah, I think that case in Germany is quite interesting. I similarly, I'm not involved in the case, so I don't know all the details, but they do seem to be overcoming the issue that, James was just talking about using their violation of the privacy laws as a way to get a competitive advantage. I think that's quite interesting. I think I understand that you have a Consumer Protection Bureau for a reason, and those are kind of different analyses. I also think you could imagine, setting aside anything about this case that I don't know the details on, you can imagine companies using violations of consumer protection laws to advance their own business and harm competitors. I can sort of conceptualize it more even when you think about deception, right? So it's not sort of unheard of that a company would be able to, I don't know, it doesn't even have to be a platform, but use their business to, engage in deceptive actions that not only harm consumers, but also harm the competitive process. And if they're dominant, maybe, that's something we should think about from an antitrust perspective. I mean, the facts would have to be there to support the case, but at least I can conceptualize that. And I can imagine in the privacy space, there's room for that as well. But kind of to your specific question, I think when we were preparing for this, you also flagged a case that was recently brought in January, also against Facebook, Reveal Chat, which is a class action that talks about a few theories of ways that platform could harm competition using data. So, among the allegations in that case, there's an allegation, at least in the complaint, that Facebook had foreclosed rivals by cutting off their access to APIs. And that's like the functionality and data that those companies needed to compete with Facebook. I mean, we'll see where that ends up, but that's the theory in the case. Similarly, they argued that Facebook actually created data sharing agreements and a whitelist that their rivals had to sign on to in order to have access to Facebook. And through that, Facebook was actually able to engage to obtain additional third-party data. I mean, whether or not that ultimately proves to be an anti-competitive issue, we'll see. I mean, arguably, the counter to that is that, Facebook, in collecting this data and pooling data, has the potential to create better products, targeted advertisements, offer content that consumers find more useful, much the way James discussed. So, you can see sort of the flip side of that as well.
Thank you, Jamillia. And so I want to go to Michael. And Michael, I want to get your views on this. How can data be used in anti-competitive ways? And in your view, what's the intersection of antitrust and privacy considerations and the relationship between market power and privacy?
Oh, I'm not on mute. See, now I've done it both ways. Yeah, so I think the way I think about this is, look, data is a competitive asset like any other asset, and it can be used in a way that is anti-competitive. Like most assets, most of the time, it probably is not. It's not used that way. But imagine you have two companies that have different data, and they're competing with each other, and they merge, and the result of them merging is that company now sort of has so much more data than anybody else in the marketplace that they can have created a sort of wall to competition, right? I mean, like that just sounds to me like your typical Section 7 theory. So, I think when one's thinking about data, the question is what's being done and why is what's being done with it a problem or not a problem. And I think the way mostly, not mostly, but again, I think going back to my first answer, right, I think a lot of what large amount of data may do is it gives companies the ability to successfully employ other strategies that are anti-competitive. Right, like so I think a lot of times that's what people are upset about, or that we haven't thought about as much. But right, so for example, there was a transaction, and so I'm going to talk. It's a justice transaction because there are 3 FTC alumni, and we know that the FTC has never made a mistake, ever. And that includes the serial case. We're all sworn to say that. But right, the Google ITA transaction that the Justice Department investigated and required a consent. But sort of a decade later, what the people are concerned, what they look back at is they sort of say the Justice Department, and again, I'm actually not criticizing the Justice Department. This is just sort of make the point on data, saying what got lost was Bing was relying heavily on ITA to build a travel search function to compete with Google. And once Google owned ITA, even with the walls, Microsoft's view was there's no way we can tie our financial success to the subsidiary of our competitor, right? So, like, again, there's another way in which, and that may be true. That may be true. That may not be true. But it's certainly the hype. If true, that doesn't strike me as a particularly bizarre or novel theory of how a merger involving data, how data becomes what makes a merger anti-competitive. And on the privacy issue, it's really fascinating, I think. And I think James made some really good points. And look, I think I sound like a broken record. I think it really depends on what's going on. And if you could show, right, that a merger by eliminating rivalry means the resulting company is going to employ a different privacy standard a lower privacy standard, again, that strikes me as entirely reasonable, straightforward Section 7 case. Similarly, it may be where a company's using exclusionary conduct in a way that allows it to then exploit data. Again, that would just be part of a standard anti-competitive story. What's really I find fascinating is particularly with platforms that are ad supported, where what they're trying to maximize is eyeballs. It's not clear necessarily that competition leads to better privacy, because what they want is eyeballs, and what the sociologists seem to tell, right, and this is incredibly sort of bleak, right, is what keeps eyeballs on the screens are all the worst things, right? So they're going to try to keep people on the screen doing, sending disinformation, triggering flight or fight response, and in turn
explains so much, Mike.
Yeah, I mean, right. I mean, one story about about what happened in the 2016 election is not that the platforms had no idea what they were doing. They were just, but their algorithms was just like, keep people on YouTube as long as possible because eventually they'll hit an ad, right? But then in turn, they may the best way to monetize it is to have very weak privacy, which may or may not be good. But right, I think particularly in privacy, one has to be careful to be confident that what you're looking at in terms of antitrust enforcement, you think more competition will add. If your concern is privacy, you need to be sure that you have a good theory and evidence that more competition will lead to better privacy.
Thank you, Michael. And I'm hoping the 70 attendees are not watching the web going to the lowest common denominator, because they're all joining us today. So hopefully there's some thirst and hunger for good content online, but point well taken. And so we have actually a couple of good questions from the audience, but I'm going to hold off just a second so that we can at least touch upon nascent competition before we close. And with that, I want to move to Bruce. Bruce, can you give us a little bit of background on some terminologies that's floating out there, and they seem to be semantically melding into each other to some degree. I'm not, whether we should keep them separate or it doesn't really matter. Nascent competition, potential competition, killer acquisitions, these are all floating out there. And as a follow-up, given your recent run at the FTC, can you talk a little bit about some of the agency actions that have been brought under these umbrellas? And what types of cases gave you the most pause as a regulator, the top attorney there, as to what we should be really looking at?
So a couple things. Let me maybe answer the last question first. I mean, the cases that would give me the most pause as an antitrust enforcer, and we're going to talk about potential competition cases here, all these, not something where I have a merger to monopoly in an existing industry. I will leave that aside. But we're talking about something that's a little harder to define than that, some kind of future competition or potential competition. And look, we don't have a good economic theory to predict losses of potential future competition, right? So it's not like horizontal mergers where we have very robust economic theories on that, or vertical mergers where we have not quite so robust, but still theories. With future competition, it's harder. Economic theory doesn't point you necessarily in one direction or another. So what you tend to look at with those kinds of mergers, and the ones that give you the most pause, are the ones where the company's documents, the acquiring firm and the selling firm, or other market participants' testimony and documents indicate that they think there's going to be a problem in the future. Where the company, the acquiring firm, for example, thinks, hey, this firm I'm acquiring is a big potential threat to me, and I've got to squelch that threat by buying them. And by the way, people actually write those kinds of documents. So I'm not making this up. I mean, you see transactions where that's, purpose per transaction, eliminate future potential threat. I mean, those exist. People write that stuff. And we tend to believe them. Executives, you tend to have some faith that business executives know what they're talking about, or at least directionally so. So that's what gives you the most pause, I think. What I would say is, on terminology, I think there's really kind of two different things here. One is the nascent or potential competition, and the other are killer acquisitions. Potential competition refers specifically to a series of antitrust theories, weirdly enough, call perceived potential competition and actual potential competition, because we had to make things as confusing as possible. But those had to do with whether firms were either already exerting competitive pressure in a market in which they didn't participate directly because of their obvious ability to enter it, or where firms are likely to enter in some very near term in the future in some definable way. Right? Those were recognized theories, and there have been cases, a number of cases in those areas. Nascent competition, I think, sort of takes that concept a little bit further and says, well, what if we have a transaction where it's pretty obvious that the purpose of the transaction is to eliminate a future competitive threat, or a threat from a firm which maybe poses a little bit of a competitive constraint now, but is likely to pose much more of a constraint later. I don't view that as being different in some fundamental way from the potential competition cases, but I do think those are legitimate cases, but they turn very much on what the evidence is. And it's not the situation where we can just make assumptions one way or another about what the competitive outcome will be. You really have to have some evidence to support enforcement. Killer acquisitions is a little different. And this has to do with cases where firms are buying potential rivals for the sole purpose of eliminating them as future threats, even where there may not actually be much demonstrated market impact at the time. There have been some papers on this, notably in the pharmaceutical industry, where the authors concluded that there was pretty good evidence that a lot of below HSR threshold acquisitions, were done for purely anti-competitive purposes, where the product that was bought, which was typically a developmental product, a drug that was in the pipeline, just was immediately squelched, never saw the light of day. The R&D efforts were terminated. That was the end of the story. The FTC has talked about this in the context of, what if you have a firm that has a pattern of identifying, buying, and extinguishing future threats without any regard to any efficiency in a merger? Right? It's not buying them because there's talent there you want to get. It's not buying them because there's IP that would be useful, or know-how, or customer lists, or anything. It's simply identifying, buying, and eliminating potential rivals solely because it has identified them as potential rivals. And could that be a basis for enforcement? And I think there's some good reason to think it could be. Some examples of cases along these lines, the Mallinckrodt Questcor case from the FTC was, I think, basically a killer acquisition type case. And if you're lumping these, if you're doing a taxonomy, I would put it there. CDK Automate, which was a digital platform merger case that we brought when I was at the FTC, and Illumina PacBio, which came kind of at the end of my tenure there and sort of went past when I was there. Those were cases that I would fit more into the nascent potential competition space as examples of the kind of case that you would look at to see what the government's thinking about that kind of theory.
Thank you, Bruce. I'm going to move to Jamillia, and then I'm going to move to hopefully a question or two from the audience, because they're really good. And I know we're running out of time, so I want to be sensitive to everyone's time and not take too much of it. So let me move to you, Jamillia, about false negatives and false positives. And false negatives were permitting anti-competitive acquisitions or conduct, particularly in the context of nascent competitors, as well as false positives, where this is where we're prohibiting pro-competitive conduct. And there's the famous Frank Easterbrook proposal that really it's the false positives that we need to be worried about. And critics have said, well, things have changed because of the nature of platforms. So I want to pose a question to you. Do you think the agencies are too concerned with false positives and are letting some anti-competitive mergers go through?
So yeah, it's a good question. In my experience, though, I don't see that ultimately kind of an overarching view of false positives or negatives is really what's driving specific enforcement decisions in the merger context. There have been instances where I've represented complainants before the agency, and I thought the complaining parties had a legitimate concern, and nonetheless the agency didn't bring the case. I mean, it's entirely possible, though, that that's not because of concerns about false positives, but rather we were either looking at different evidence, or they had evidence I couldn't see. They weighted the evidence differently than I did. We just reached a different conclusion. And similarly, I've been involved in cases, and for example, in Illumina PacBio, where we were involved, where I took a different view of the evidence and the likelihood of PacBio becoming a potential competitor. Is that because some overarching view towards false negatives or positive? I just think it's evaluating evidence differently. That being said, the concern, there is so much dialogue about missing things and missing mergers that the agency should have taken a harder look at or thought of broader theories. And I don't think there's necessarily harm in that conversation either. If that's driving the agencies as law enforcement agencies to look harder, think about deals differently, think about platform competition differently, it's hard to say that's a bad thing, right? If they're law enforcement agencies and need to come to the right conclusion, but from the law enforcement agency's perspective. But at the end of the day, it seems to me that kind of weighing the evidence on specific cases is more the driver than being particularly concerned about false positives in the merger context.
That makes a lot of sense. And so, Michael, it looks like the audience questions, they have spoken and the market wants to talk about big data and privacy. And so I'm going to shoot this one to you. An attendee has a specific question for you. How should we think about the argument that for more onerous privacy regulations, they cement dominant positions because of the cost of compliance, such as GDPR? Do you think that that's kind of weighing in, and maybe that should be a consideration when we are trying to pass these regulations?
So I'm going to deflect first, because I seem to have a little more market power. Actually, I'm going to deflect. I'll answer the question. So, this has become a really hot topic, and I think if you're a lawyer of my generation, we all learned that regulation often has the unintended consequence of protecting entrenched monopolists. The example of that the sort of getting rid of cigarette ads on television actually helped the big guys, not the small guys. Separate public policy question whether that mattered. So I think it's like the job of regulators is to write the best regulation, and yes, they can be subject to capture, but again, it's the facts of the situation. So they should be thinking about when they're looking at regulation, what is the impact on competition? But at the end of the day, it's actually it should be a sort of democratic policy choice, how much you want to protect privacy versus competition, right? So we make that choice in the drug industry. Even though it would be a lot easier to enter drug manufacturing if there was not requirement that you get your drug approved, we don't, that doesn't, we make that choice. So I think it's something they should be considering, and it goes into the policy judgment, but I don't think it's a dead weight. On the false negative, false positive, I think, so there's two things to think about. One is, I think actually where it has its effect is before you get to the agency, it's where the case law is, that the courts are so worried about false positives that they have set up legal rules, particularly in the conduct area, refusals to deal, that I think have led to massive under enforcement, and particularly say in pharmaceutical antitrust with pay for delay or hospital mergers, we now know that overly lenient antitrust rules are really expensive, and that maybe false positives aren't as expensive as we thought. And in this context, what's interesting about the false positive, false negative in this context, it's going to Bruce's point about nascent competition, is if you have a market with network effects, entry barriers, and tips, you would expect the normal course of that market is going to be, you're going to have long periods of dominance and then these sort of fights, massive fights. And it's really a lot of consumer benefit occurs in that short period of fighting. So that means that actually making that mistake and under enforcing at that moment is going to be highly costly. And so I think it should shift how we think about that balance in that context.
Thank you, Michael. So I think we have time for one more question. I'm going to go to James to close us out here. James, I'm going to go to the audience question again here, throwing you a little bit of a curveball. Since third-party apps were a major source of user engagement and growth for Facebook during a formative time in 2010 to 2014, do you see the Facebook Cambridge Analytica incident as an antitrust issue, meaning there's a turn to data exfiltration, there's a word, by third-party apps to see what companies would be competitors? Privacy, consumer protection issues, is this just privacy and consumer protection, or is it both antitrust? And so what's your view on that incident, James, in the formative time of Facebook?
Well, first, I like the use of exfiltration. I watched Argo a few, and it's all about exfiltration. So that's twice I've heard this word in the last week. So that's great. But leaving that aside, I think that what the question is getting at is actually very similar to the question you posed to Michael, is kind of this privacy antitrust, privacy regulation and its impact. So it is hard, and at the 50,000 foot level, and then I'll try to address the Cambridge Analytica thing more precisely. But at the 50,000 foot level, I mean, privacy regulation is often about limiting data, limiting access to data, and we've talked on a lot in this panel, and it's data in data-driven platforms. When we talk about big data, it can be a competitively advantageous asset, and so privacy regulation can lock that data down, and it makes it harder to it can very much it can make it harder to move data from one platform to another. There's a tension of this when you have data portability requirements. Well, that goes the other way. Maybe it's good for competition, but then privacy advocates would say, well, it's good at allowing you to take your data from Facebook and go to somewhere else, but then again, you're freeing up the data. So there seems to be tension there, and and I think that you see this with there's some good work by Leah Wagman and Ginger Jen, and I apologize, I'm forgetting their third co-author, on the impacts. I think it's out in Marketing Science or Management Science, on the impacts of the GDPR regulation on venture capital investment in Europe versus the US. Really well done, kind of treatment and control group. And not surprisingly, if you can't monetize your data and the GDPR kind of locks down data compared to the US, VC funding is going to dry up. I mean, that would be the hypothesis, and the data, at least in their preliminary studies, seem to show this. Now, talking about Cambridge Analytica in particular, I think that's actually something that's come up in some of the discussions. That exact trade-off is that you say, okay, the privacy issue here is letting third-party APIs have access to Facebook's cache of data to make applications. Well, the Cambridge Analytica was all about that being out of control, everyone having access. So what do? You lock it down with a $5 billion 20-year consent order with the federal. Well, it's not it's a violation of a prior consent order, but another 20 years tacked onto that with these kind of heavy-handed privacy regulations. Now that can be good or that can be bad. Nonetheless, there are going to be competitive effects. If you're saying Facebook, you've got to lock your data down more, and there you see, that to the extent that it hinders third parties from developing apps on the platform that maybe someday be a competitor to Facebook, there can be a competitive problem there.
Thank you, James. And with that, I don't want to take any more time of the attendees or the panelists. I really want to thank everybody for tuning in, certainly, but I want to thank Jamillia, Bruce, Michael, and James for your excellent insights and discussion. So thank you all, and this will close us out. Thank you.
Thanks, John.
Thank you. Bye, folks.
Bye.